Hello everyone, I am Mansi Asija and I am working with LEXIS and Company and my today's topic is contract. According to Indian Contract Act, what is contract? As it is defined in section 2H, a contract is a lawful agreement. In other words, you say an agreement enforceable by law is a contract. Contract is agreement plus legal enforceability, or you can say contract is legally enforceable agreement. A type of agreement which is enforceable by law is a contract. Section 2H of the Indian Contract Act. Enforceable by law means that if somebody is aggrieved, then he may approach the court for remedies. Let's take an example. In case of a fire insurance contract, Mansi wants to insure his goods in the warehouse. He pays the insurance premium and promises to avoid insurance fraud, whereas the insurance company agree to compensate losses in case of a fire. Okay. Agreement plus enforceable by law is contract. When an offer is made with the intention to create a legal obligation, it becomes an offer for entering into a contract. Thus, an agreement becomes a contract when there is free consent of the parties, capacity of the parties to contract, lawful consideration, or lawful object or subject matter. It is mentioned in Section 10 of the Indian Contract Act. For an agreement, for an agreement to become a contract, it must give rise to a legal obligation, and if it is capable of doing so, then it is not a contract. Uh, it is a landmark case, that is Balfour versus Balfour in 1999. What a court said? What is the judgment? Mr. Balfour, what is the facts? Mr. Balfour promised to pay his €5 30 per month to as he stayed in England for medical reasons. Okay. When he failed to pay, Mrs. Balfour sued him. Her action failed because there was no intention to create a legally binding agreement between Mr. and Mrs. Balfour. Contract cannot be made without proper indication about the legal rights and obligation of the parties of contract. So, in this case, if there were to be a contract, then the wife would have had a right to receive payment, and thus the husband would have had the obligation to pay his wife. Okay. So, an agreement in a contract. Oh, sorry. An agreement is a contract when when agreement becomes a contract. First, free consent of the parties. When there is absence of coercion, section 15. Undue influence, section 16. Fraud, section 17. Misrepresentation, section 18. And mistakes, section 20, 21, 22. The consent is said to be free. Second, capacity of the parties to contract. In section 11 and 12, lay down that the competent parties are persons who have attained majority. Exception for this was laid down in case Mohari Bibi versus Darmodas Coos. This is also a landmark case. Person who are of unsound mind and person who are not disqualified by law. Okay. Third point, last point, lawful consideration and lawful object. Section 23 lays down that the consideration and object is lawful unless it is forbidden by law, or it defeats provisions of any law, or is fraudulent, or involves injury to a person or property, or is violative of health, public health, morality, peace, and other. Let's take an example of where agreements are not contracts. First, Rajesh promises his wife Chitra that he will bring for her stars, the stars and the moon, and Sonam agrees. Here, the object of the agreement is impossible to perform, and so it is not enforceable by law and cannot be termed as contract. Uh, Now, types of contract. First, valid contract. It is on which I'm just telling the types of contract that on the basis of its enforcement. First, valid contract. An agreement enforceable by the law is a contract. In section 2H, to be enforceable, it has to satisfy the requirement under section 10 of the Indian Contract Act 1870. There is some consideration for it. The parties are competing to contract. Third, their consent is free. Their object is lawful. Now, second, voidable contract. Section 2I of the Act defines a voidable contract, an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other, is voidable contract. A voidable contract remains valid until rescinded. A voidable contract can be made valid by the party who has a right to rescind it by giving up his right of residing it. Third, void contract. A void contract is not enforceable at the option of either party. Section 2G of the Act explains the meaning of void agreement. Fourth, unenforceable contract. It is one which is good in substance, but because of some technical defect, one or both parties cannot be sued of it. These defects may be the absence of writing, registration, time barred by the law of limitation, etc. Fifth, illegal or unlawful contract. Section 23 of the Act describes some conditions when an agreement may be unlawful or illegal. A distinction has to be made between void contracts and illegal contracts. Agreements whose object or consideration is forbidden by law are called illegal contracts. In the case of void agreements, the law may merely say that if it is made, the courts will not enforce it. So I think now you got the meaning of contract and types of contract. Hope so you will like it. And thank you for watching this video. And please subscribe this YouTube channel and this video. And thank you so much.